Until this point, I wasn't aware that I was being falsely accused of intentionally
Yeah,
quitting my
that's not my
job.
question.
Have you asked Mr. Reyes to let the OAG know every time he had increased his income?
Yes, I have. I rent out a bedroom from my parents. I still live at home.
Since the last child support review in 2014, have you accurately notified the OAG every time you had an increase in your income?
He's never had a problem with employment before, and now all of a sudden he can't find a job.
This remark about me intentionally quitting my job is some nefarious statement that I wouldn't do because it jeopardizes Shannon and I's son's well-being.
My client has watched Mr. Reyes make more and more and more income since the last review in 2014.
Not represented by an attorney, correct?
That's correct.
Okay, so Miss Conrad, you're here with Miss Larson. All right.
You today. Mother is asserting that dad basically quit his job insincerely so that he could avoid paying child support payments. This is a modification today. So there was I think there was a conference back in June or July of 2023 where the parties reviewed the case and discussed whether modification was appropriate. It was right around that time that Mr. Reyes lost his job. Mr. Reyes will tell you that he just simply lost his job, that there was no nefarious motive. Mom disagrees. Currently, Mr. Reyes is unemployed and is working for Instacart. So you will hear two sides of that argument, that his leaving his job was sincere or it was insincere. The state is essentially requesting that the judge order child support guidelines and medical support at 4.5% of whatever amount that the court deems is appropriate. So the state, whatever amount the court finds that the father should be paying, either the amount that he was making before he was laid off or the amount he's making now. We have an agreement to the amount he's making now. We have an agreement to the amount he was making before he was laid off. And so whatever amount the court decides to go off of, the state is requesting a medical support amount of 4.5% and then child support based on the guidelines. The state is requesting temporary orders moving forward until dad can find a job.
All right, so it has been 10 years, nearly, from the last order. So a lot of history has happened in between. Okay, so I suspect that you're going to be able to put on some evidence of what income Mr. Reyes had prior to loss of employment in July of last year, correct?
Yes.
Okay.
Yeah.
I think I understand where you're going.
Okay, good. Good. That's good.
Was there what is the stipulated amounts that were calculated?
So the stipulated amount of current income is $1,750 a month. That's current income. And then the amount that Mr. Reyes was making before he was laid off in July is $65,000 a year. And that comes out to a monthly gross income of $5,416.67.
Okay. Go ahead. I'm sorry.
It's okay. The state is also requesting arrears too. And I will show you that exhibit during testimony, but yeah, I did send it to the court. So the state is also requesting arrears on child support and medical support.
Were those amounts, the balances that are owing, was that disputed, or is that also, was that a stipulation as well?
That's a stipulation. Yes.
Okay. Now, since you're requesting temporary orders, were you requesting confirmation of any judgments within that temporary order?
Yes, confirmation of the child support judgments and medical support judgment as of April 1st. Okay. And then lastly, and by the way, I have calculated those numbers of medical support and child support based on either current income or past income. I can show that on my closing. The last request the state makes is to order the non-custodial parent, the father, to participate in NCP Choices so that he can more quickly find a job.
Okay. Now, Ms. Nichols, just to save a little time, because I do see the hour, it's 11 o'clock. So let me just ask Ms. Larson. Ms. Larson, the amounts that are due for past due child support and medical support, is that disputed, or are you stipulating that that is what is owed?
We're stipulating to that.
Okay, and Mr. Reyes, are you also in agreement that the balances that are owed at this time on child support and medical support, as reported by the Attorney General's office, is that also your agreement that that is what is owed?
Yes, I did, on the past balances, I do agree. There were some questions I did have about the medical charges.
Okay, great. So Ms. Nichols, if you could announce on the record, what is the balance owing as of April 1, 2024 for child support?
It is $1,455.14.
Okay, and for the medical support?
$452.64.
Now, was there an agreement as to a payment plan for those two amounts?
Not necessarily an agreement, but I did tell Dad what would be appropriate, and he said, okay, that works.
And what did Mr. Reyes agree to pay on past due child support?
$57 a month.
Okay, and is that acceptable, Ms. Larson? To your client?
Yes, Your Honor.
And Ms. Nichols, and what was the agreement for past due medical support payment per month?
$52 a month.
Okay, and Ms. Larson, was that also appropriate for you, for your client?
Yes, Your Honor.
Thank you. All right, and so Ms. Nichols, I'm going to assume that these payment plans will begin May 1st.
Yes. Could you please state your name for the record?
Yes, it's Stephen Reyes.
Okay. Are you the father of the child in this case?
I am.
Okay. Earlier you heard me mention to the court some agreed issues. Are you in agreement with the amount of gross monthly income you're making now?
I am.
Are you in agreement with the amount of gross monthly income you were making before you lost your job?
Yes.
Are you in agreement with the amount of child support arrears that you owe?
Yes.
The medical support arrears?
Mm-hmm.
Are you in agreement with moving forward with a monthly payment plan for the child support arrears at $57 a month?
I do agree to that.
Okay, and the medical support at $52 a month?
Yes.
Okay. All right. Mr. Reyes, I want to go back to the day you lost your job. When did you lose your job?
I lost my job on July 7th, and I provided documents to the court showing my resignation letter from my former company.
Okay. Would you like to introduce that as an exhibit?
I would.
Okay. You can go ahead and request that from the court.
Okay.
Mr. Reyes,
Yes.
I don't know if I have it, but did you, when did you send that to the court?
I sent it in, let's see, maybe about an hour ago. I sent it to the court and to Miss Nichols.
Okay. And so Ms. McKnight, I see you're on the screen.
It should be in the folder under 702.
Okay.
There
All
it
right.
is.
All right. I see it now. Okay. So Mr. Reyes, did you share that exhibit with Ms. Larson?
Up until this point, I wasn't aware that I was being falsely accused of intentionally
No,
quitting
that's
my
not my
job.
question.
Oh, I haven't. Sorry.
You have not. Okay. So are you able to share your screen so that Ms. Larson may see your exhibit?
I can email her a copy.
That would be great. So, and that I see you sent a copy to Ms. Nichols, but you didn't send it to Ms. Larson. Okay. And this would allow Ms. Larson to be able to announce any sort of objection she may have or no objection. So while you're doing that, Ms. Nichols, did you have an objection to Father's Exhibit number 1?
No objection.
Okay. I'm gonna pause our record, well, until Mr. Reyes lets us know that he sent off that exhibit and also that Miss Larson has received it.
Okay, I've sent it over.
Okay. Miss Larson, let me know when you receive it, and that way you'll get a chance to review it.
I just received it from Mr. Reyes.
Okay, I'm gonna go ahead and get us back on. Thank you, Ms. McKnight. All right, Ms. Larson, I'll give you a moment to review Mr. Reyes's exhibit number 1 and see if you have any objection.
I do have an objection to the authenticity of it.
Okay, Mr. Reyes, I need for you to respond to the objection.
Yeah, what's the objection?
Authenticity.
Okay, well, what are you questioning its authenticity about?
If you could just lay the foundation, please.
Mr.
Uh,
Reyes?
Okay. You know, I'm not quite too sure on what I'm not needing to be presenting. This is our company's letterhead. This is the day. This is the letter I was submitted when I was walking out of the office. So I'm not sure what I need to provide. But do you mind explaining what I need to express?
I'm sorry, Mr. Reyes, but neither the court nor Ms. Larson can help you with any of these procedures.
Okay. Well, I'm not sure what to say then.
All right, so what you're arguing is that the letter is something you received from your employer and you were walking out the door when you received it.
Yes.
Okay. Anything else, Ms. Larson?
No, Your Honor.
Okay, the objection is overruled and father's exhibit number 1 is admitted. All right, you, Ms. Nichols?
Mr. Reyes, since this is your exhibit, would you just go ahead and explain the letter to the court?
Yes, the letter explains that this is a force and reduction from the company, and it states the last day I was employed. It goes over my my separation agreement, and that's regarding health insurance, medical insurance, where I need to go as far as getting a short-term insurance. It also states company material I need to give and when my last paycheck I was going to receive. Um, Other than that, yeah, it's pretty straightforward.
Okay, thank you, Mr. Reyes. Um, since you lost, the letter you're referring to, since you lost that job, what have you been doing for work?
Currently, I've been doing Instacart until I find an adequate job. I'm looking for a job that pays roughly around the same I was making previously. I do have a few job interviews lined up, but I am only working at Instacart at the moment.
I have no other questions for Mr. Reyes, Your Honor.
Ms. Larson?
Yes. Since the last child support review in 2014, have you accurately notified the OAG every time you had an increase in your income?
Shannon and we had another mediation back in 2020 or 2021, and I did inform them of my pay increase back then.
And was your child support increased at that time?
It was not increased at that time.
Was there a reason given to you why it wasn't increased at that time?
Not that I'm aware of.
And since 2014, have you been employed?
I've been employed with the same company, yes.
And what was your job title when you were laid off?
When I was laid off, my job title was inspection supervisor.
And what was your job title before that job title?
I was an assistant manager.
And were you demoted?
No, I chose to move back to Austin. So that's why I took a different title change.
So was it a decrease in income?
It was.
And when did that change occur?
That changed at the beginning of 2023.
And was this around the time that Miss Conrad notified you that she would be starting a new child support review?
I was under the impression that it was our annual child support review.
So you believe that these reviews happen every year?
I was under the impression there was a cycle.
And have you told Miss Conrad that you would rather quit your job than pay her child support?
I don't think I mentioned anything like that.
And since when you changed positions at your company, did that increase your likelihood of getting laid off?
No, I think it was a more of a company decision. There were a few upper management people that were also laid off.
And since you were laid off in July, how many jobs have you applied for?
I've applied to about a dozen different jobs.
What kind of jobs?
Same solar cells, same in the same industry. I'm trying to get roughly around the same salary I was making before.
And how often do you see your son?
Weekly.
Every week?
Yeah.
And are you aware of his learning disability?
I wouldn't say he has a learning disability.
Are you aware that he was getting tutoring regularly?
I'm aware of his tutoring.
And are you aware that Miss Conrad was forced to stop his tutoring at the beginning of this year?
He's been going up until maybe a week or two ago. She told me that they were going to take a break though. I assumed it was for summer.
Okay. And are you aware that you've been court ordered to pay attorney fees in this case?
I wasn't aware of that.
Okay. And so prior to July of 2023, you had been employed the whole time?
I haven't had a job or a W-2. Yes, that's correct.
Okay. I will pass the witness.
Ms. Nichols, any other questions for Mr. Reyes?
No other questions.
Okay, did you have another witness to call?
Yes, I'll call Miss Conrad.
Okay,
Good morning, Miss Conrad. Could you please state your name for the record?
Good morning, it's Shannon Conrad.
Are you the mother of the child in this case?
Yes, I am.
Does your child have health insurance right now?
Yes, he does.
Okay, is it private health insurance?
No, he's on Medicaid right now.
Okay. Are you aware that Mr. Reyes is in arrears for child support and medical support?
Yes.
Okay. And do you have any let me see. So what is your response to Mr. Reyes to the letter that he introduced? What is your response to that?
I'm not really sure where the letter is. Where would I find that?
Or I guess a better question is, what is your response to Mr. Reyes stating that he was laid off because of a reduction in force?
Well, I know that he stepped down from his manager position as soon as I told him that we would be doing a review. And I feel like that kind of affected him getting laid off. It just, like, if you look at his income history, it just seems like he's never had a problem with employment before. And now all of a sudden he can't find a job. You know, it just seems like he's staying underemployed to pay as little as possible when I'm financially struggling. My son had to stop tutoring because I can't afford it anymore. He does have a learning disability. He suffers from dysgraphia. He was tested for it and everything. And now his grades are suffering since he's been taking a break. And he's about to start high school, so I really want him to pass 8th grade.
Okay, I don't have any more questions for Miss Conrad.
Ms. Larson?
Yes. Ms. Conrad, since the last child support review was conducted in 2014, have you asked Mr. Reyes to let the OAG know every time he had increased his income?
Yes, I have.
And are you in agreement that the 2014 child support review set his child support amount at $316? And did you decide to start another child support review last year once you realized he wasn't letting the OAG know about his income?
Yes,
And are you in agreement that at the time that he was laid off, he was making $65,000 a year?
yes,
And prior to stepping down from his manager position, he was making about $75,000 a year?
correct.
And is this the first time that you're aware that he's been unemployed for any amount of time?
Yes, it is.
And tell us a little bit about how much you spend on your son every month.
So I spend about 1,300, 1,400. I rent out a bedroom from my parents. I still live at home. That includes tutoring, food, groceries, entertainment, just everything that you pay for when you're raising a child. Soccer registration, things like that, extracurriculars, clothes, school supplies, yearbooks. I mean, there's monthly costs and then also about 2,300 yearly. So,
And I'd like to enter petitioner's exhibit 1, and I can share my screen if necessary. These are the invoices from his tutoring for grade power learning and from mathnasium.
Exhibit number 1. So Mr. Reyes, did you, have you had an opportunity to review exhibit number 1?
I have.
Okay, do you have an objection?
I don't have an objection as more, no, I don't.
Okay, Ms. Nichols, any objection to exhibit number 1?
No objection.
Okay, Mother's exhibit number 1 is admitted.
So, Ms. Conrad, is it accurate that you've spent about $13,000 on grade power for your son?
yes,
And did you have to stop paying for it at the beginning of this year?
yes,
Are you unable to afford it at this time?
yes, unable to afford it, and his grades are being affected.
So you can already tell since you stopped it in January that his grades are slipping?
Yes,
And are you worried that he will be able to get into high school and succeed in high school?
yes, I am worried about that.
And do you work a full-time job?
Yes, I do.
And do you have to take additional work beyond your full-time job?
Yes, I do.
And is that all just to make ends meet for your son?
Yes,
And has Mr. Reyes ever told you that he would do everything possible to avoid paying child support?
yes. He told me that he would quit his job just to spite me one time when we were talking about possibly raising child support, that he would find a way.
And are you asking that he be ordered to pay child support based on the income he was making prior to being laid off?
Yes,
And are you asking that it be retroactively applied to when he first had notice of this child support review?
yes,
And are you also asking for attorney fees that were necessary and reasonable to prosecute this?
yes.
I pass the witness.
Ms. Nichols, any other questions?
No more questions for Ms. Conrad.
Okay. And does the state rest?
Yes, the state rests.
All right. Ms. Larson, did you have anything else, ma'am?
Just a quick closing statement if the court had time.
Okay, all right, so let me turn over to Mr. Reyes. Mr. Reyes, it looks like both the state and Ms. Larson have put on their case. Now would be a time for you to provide any additional evidence or testimony you would like to give, and so you may do that now.
So from what I've heard so far, everything seems accurate. I think the only objection I do have is to Ms. Conrad's last comment regarding the grade power tutoring. I actually picked him up about a week or two ago from grade power. He's been in it, and I don't necessarily see his grades failing as far as him passing 8th grade to going to high school being relevant, because he's actually doing really great. So I'm not sure why the picture's being painted that he's been struggling into that. And also this remark about me intentionally quitting my job is some nefarious statement that I wouldn't do because it jeopardizes Shannon and I's son's well-being. And I've had a stable job over the past 14 years to provide for Conrad anything he needs. And I don't think that I would have made a comment like that. I think that Shannon and I have got into some heated arguments before, but I don't think I would maliciously do something of that caliber to spite her. So I just wanted that to be my closing argument, I guess.
Thank you. Ms. Nichols?
Yes, I have a closing statement.
Thank you. You may proceed.
So if the court decides that child support and medical support payments should be set at Mr. Reyes' current income, the amount of medical support, I have the numbers, would be $79 a month. Child support set at $297 a month. If the court decides for the temporary orders that Mr. Reyes's support should be set at, or the gross monthly income should be set at the time that he was laid off. The medical support payment is $244 a month. The child support payment is $849 a month. The state is also requesting the court to take a judgment on arrears for child support and medical support as of April 1st, 2024, and that Mr. Reyes be ordered to make monthly payments to pay off those arrears for child support at $57 a month and medical support at $52 a month. And again, this the state is requesting this for temporary orders and then for us to come back in a few months when Mr. Reyes is able to find a job and we can make final orders.
Did you have a proposed court date in future, or number of months that you would like to have this case?
3 or 4 months. 3 months.
So that's maybe August.
Yes, August should be fine. And I do have one. I'm sorry, Your Honor, I do have one clarifying statement.
Okay.
The state is requesting, rather than taking judgments as of the 1st of April, it would be at the end of last month. So I suppose that is, we have March 31st. So let me see. So that amount does change slightly. If you wouldn't mind, let me calculate those numbers while Miss Larson gives a closing, if she's able, and I can tell you after she gives her closing.
Ms. Larson?
Yes, Your Honor. My client has watched Mr. Reyes make more and more and more income since the last review in 2014. And she has asked him over and over to provide accurate income information to the OAG so that the child support payments would accurately represent the amount that he was making. And then as soon as she, gave up on him just doing it without the formal process and started the formal process of child support review, he stepped down from his manager position to make less money after telling her that he would deliberately do anything to not pay her child support. And after they had the negotiation conference in June of 2023, he was laid off the next month. And now in the last 9 months, he's testified that he's applied to a dozen jobs and is making $1,700 a month as an Instacart person. He's strategically opting out of being fully employed to evade his responsibility for child support payments. And it's directly to the detriment of his only child, because my client has struggled for years to make ends meet and make sure that he got the tutoring necessary to be as successful as possible in school with his learning disability. And she's just not able to make all of those payments now. And her son is suffering because of it. So that is why we're asking that his child support should be assessed at his purported income of $65,000, because he has shown that he's able to make that much, and he chose to step down from a more protected position and end up laid off instead of paying the child support needed to take care of his son. And again, we're also asking that that be retroactively applied starting when he had notice of this review.
Let me know when you're ready, Mr. Nichols.
Okay, so if we're taking a judgment on arrears as of March 31st, 2024, the amount of child support arrears in total is $1,139.14. Medical support arrears as of March 31st, 2024 are $377.64. The state requested that child support arrear be paid back at a monthly amount of $56 a month, and then the medical support at $52 a month. So that amount does not change. And lastly, the state requests that the current medical support and child support moving forward for these temporary orders begin as of May 1st.
All right. I'm going to provide some information about the court, really for Mr. Reyes' benefit. I'm sure the attorneys know this role. So I'm the associate judge for the child support court here in Travis County. My decisions can be appealed. So that's called a request for a new hearing. The request for a new hearing for a 40 case must be made within 3 working days after I sign orders. So Ms. Nichols will prepare the order. It'll be circulated electronically through DocuSign. If you will know that I've signed the order because you will receive a notice of the signature, and at that time, then you can decide to request a new hearing. All right. In considering the exhibit provided by Mr. Reyes, and also the exhibit number 1 submitted by Miss Conrad. I am not sure. I wish there had been some other evidence to show maybe some text messages, maybe some emails of any sort of admissions been made by Mr. Reyes as to the allegations that were made against him, that he had planned on changing his position from an assistant manager to an inspection supervisor. What I heard Mr. Reyes say is that he had relocated from a location where he was working as an assistant manager to move towards Austin. At least that's what it seemed like. And the letter, I've taken that as the evidence to show that Mr. Reyes has been separated from his job. It didn't seem it was voluntary. It was a reduction in force. However, in calculating child support, I don't think it meets the rule for a difference between 20% or $100. So in calculating guideline support, it would suggest to be $297. And now 20% difference of what is currently being ordered is, I think, a difference of $59 or $60. So I don't think that I can reduce it. Let me see. So Mr. Reyes, your child support isn't changing. It's going to stay at the current amount of $316. And so that will continue as currently ordered. And the medical support of just changing $4, that's also not going to change. So that will stay at $75 as currently ordered. And then the judgments for past due as of March 31st are confirmed. The payment plan is requested by the state. Will continue. Now, I will say this, that when we come back in August, I think we hadn't decided on a date, but it looks like there's some room mid-August. That's after the Advanced Family Law Conference. So, Ms. Larson, are you going to be available August the 14th? You will be. Okay, you're nodding your head. Yes. Okay, so August 14th. Mr. Reyes, any conflicts with August 14th? That's a Wednesday, and it's going to be in person. You have conflicts on August
Oh,
14th?
no, I don't. I agree.
Okay. So August 14th at 8:30 will be the next setting. Ms. Nichols, I know that it has been a practice of the NCP Choices program to try to work remotely. I think that there have been some allegations that perhaps Mr. Reyes isn't putting forth the effort that he needs to find a job that is within his industry. You may as well put the NCP Choices representative on notice that they may be called to testify as to the compliance of Mr. Reyes. I know Mr. Reyes has testified that he has applied to all different types of jobs. I'm sure that's the sort of evidence that I would like to see from the NCP Choices program to see how well you are complying with the program. Mr. Reyes, you have lots of background and skills and education to obtain a job that it sounds like you're motivated to get back to earning the same kind of money you were making. Also, it would have been helpful to see if there's any sort of severance packages or severance pay that Mr. Reyes may have received from a reduction in force. It seems to be sort of a practice among employers that if someone gets separated and that wasn't presented, that would have been helpful to determine what other income Mr. Reyes is receiving other than the Instacart income. But that wasn't offered. Now, even though support is continuing, I am open, and I think I can still order support retroactive. I think I'm going to leave that up to the lawyers to figure out. But I think that when we come back in August, I think arguments can be made to whatever income Mr. Reyes is able to prove or the state is able to prove at that time, that retroactively setting support to let's see, service last party service in October back to November of 2023. You let me know, but I am open to doing that and ordering that Mr. Reyes pay if the support's going to be greater than $316, that be retroactive to November of last year. Okay, I'm going to reserve the court costs and at this time. And Mr. Reyes, you said you weren't aware of any attorney's fees. There was a hearing held recently in this case, not in this court. Okay, it was a different court, but it was held, it looks like mid-February.
I got the dates wrong, unfortunately.
Okay.
But that's
So-
completely on
So
me.
just to let you know that there was a judgment. I have not seen the order yet, but it looked, and I wouldn't sign it. It would be a different judge. But it looks like you have a judgment of $825 against you for attorney's fees. Okay.
Okay. $825?
$825. At least that's what the notations indicate was granted.
Okay.
Also, there was an order granted against you for the motion to compel. Okay, that was what was held. Okay. All right, Miss Nichols, anything else, ma'am?
Yes, I have two questions. Could you repeat the day that we need to come back? Could you please repeat that day and the time?
August 14, 8:30.
Thank you. And the attorney's fee amounts, it was $825.
No, that I was just providing Mr. Reyes information about the hearing held by Judge Arth that granted attorney's fees against him associated with the motion to compel. Okay, the AG wasn't there. I'm not granting, I'm going to reserve that issue as well. I think Ms. Larson requested attorney's fees on their counter petition.
Okay.
That's reserved. Okay.
Okay,
We'll
thank you.
fix that in August. Okay.
Thank you.
All right. Okay. We're gonna. Any questions from you, Ms. Larson?
No, Your Honor, thank you.
Okay.